Welcome to week 10, where we will dive into the judicial branch of government, and we will talk first about the structure and duties of the federal judiciary as a whole. In the coming weeks, we will then break that down by talking about the Supreme Court and then judicial behavior largely. So let's go ahead and dive right in. The first place we will stop is to talk about some of the dichotomies in the law so that we better understand the terms with which we'll be dealing in the next couple of weeks. The first I want to draw your attention to is the issue of what is the substance of the case. And this can be divvied up in kind of two ways, where the first way deals with whether the court issue is a substantive legal issue or a procedural one, and then also whether the case is civil or criminal. So first, let's look at this substantive and procedural dichotomy. Substantive law is the law that is actually at the heart of a dispute. It is what is mandated or prohibited under formal law, usually a statute created by a legislative body, but also this can include constitutional law, this can include common law as well. But the idea is that substantive law is the actual heart of the legal matter. Procedural law, on the other hand, governs the process of the law, both in and out of the courtroom related to the case, and how the law is applied to different people in different situations. One kind of key factor that we should include here that we will probably reference a couple of times in the next couple of weeks is the idea of due process of law. This is this all-encompassing term that is usually applied to mean that someone has to be afforded a fair procedure under the law, a fair shot at something. So this might mean a fair trial, this might mean adequate discovery prior to a trial. All of those things are thought of as part of due process, and more. Another one of the questions we have to think about when we are thinking about a case is whether the case is civil or criminal. Civil law involves disputes between parties that are resolved usually through monetary payment to make a party whole. It deals then with behavior that constitutes an injury to another party or a failure to comply with a private agreement. So this is a private dispute that is taken to the courts for adjudication. Criminal law, rather, deals with the legal punishment of criminal offenses that have been deemed to be prohibited actions. So it is thought of differently because it is an offense against the public, whether this is society or the state, even though there may be an individual victim at the core of the crime. So civil is governed by civil procedure, which has different rules than criminal, which is governed by criminal procedure. Usually, the more stringent rules come into play in criminal procedure than in civil procedure, because in criminal procedure, we are talking about the ability to take away someone's life, liberty, or property, and therefore, there's a heightened sense of importance with the procedures that surround it. And then another kind of fundamental question we need to ask is what types of law are relevant? And we can break these down into two broad categories, although broad, and then we'll subdivide them out a little bit, between enacted law and common law. Enacted law includes things like constitutional law, statutory law, and administrative law, administrative regulations. This is the type of law that has been written down somewhere and specified through a process that is not a legal process. In other words, that a legislative body or a regulatory body has written down rules for everybody. Common law, on the other hand, is kind of the sum of everything else. Everything else that has not been codified by statute or constitution is common law. So when we think about common law, we think about things like caveat emptor or buyer beware. as part of the common law, things that we have all kind of heard about that we know are the application of precedent and interpretation of precedent rather than the interpretation of something that is written down in statute or in constitution. Common law can be overwritten by enacted law, whether that's constitutional law, statutory law, or regulatory procedure. And common law can then go on to interpret enacted law. So they often work hand in hand, but it's very important to understand what you're dealing with because the type of interpretation that will happen will vary depending on what is the underlying law that is at hand here. What is the dispute centering on? So why go through all of these things? One, as I mentioned, this is going to be relevant as we go forward and talk about different cases. Two, it's important to understand, especially in a minute here when we'll talk about how the courts are divided up, this distinction between civil and criminal, and then what procedure governs. And finally, understanding where the policy making comes in. And yes, I said policy making with respect to the court when we talk about judicial behavior and the different types of law that are at issue there. So before we dive into how federal cases get decided and how the federal courts are shaped, one of the things I wanted to talk about is that there are many different types of cases, and odds are all the cases that you're thinking about right now are not federal cases. There is a difference between state law and federal law, and most of the time the courts that people come into contact with are state courts and not federal courts. So for a moment then, let's talk about what these differences are so you know the types of law that we're talking about. Because this is not, when we talk about the federal judiciary, all judges are all courts. We're not talking about the state courts. We're talking about the federal courts here. Federal cases are limited in jurisdiction based on either the subject of the court action, or the subject matter as it is called, or the citizenship of the parties. And that can be broken up further into civil and criminal, and we'll talk about that distinction in a minute. State cases are pretty much everything else. And most of the time when we interact with courts, they're for things like family matter claims, marriage, death, divorce, etc., name changes. All of those things are state cases, not federal cases. So odds are most people's contact with the legal system has been through the state courts, not the federal courts. Under federal law, the cases that can be heard in federal court that are civil cases, meaning not criminal, but not criminal cases, not violations of criminal law, have to meet one of two requirements. The first could be, and these aren't exclusive, they don't have to meet both of them, subject matter jurisdiction. Subject matter jurisdiction occurs when a civil claim implicates federal civil law, like federal anti-discrimination law or federal consumer protection law. Then you have subject matter jurisdiction because there is federal law that is at issue here that you are asking the court to interpret someone's actions under this law. They're not criminal. You're not accusing people of crime, and the state isn't or the government is not prosecuting a crime, but rather they are civil matters. Another way you can get into federal court in a civil case is called diversity jurisdiction. This is a civil claim between two parties who are residents of different states. So, for example, Michigan and Ohio, and the claim must involve a matter of $75,000 or more. The idea behind diversity jurisdiction is that you don't want the courts of one state to favor the resident of that state, and therefore you allow in these higher stakes cases citizens of different states to go to the federal courts for a neutral arbiter. Then criminal cases in the federal system. When we are talking about criminal cases, odds are what we are talking about is trials for violation of federal crimes. This can include things like wire fraud, money laundering, terrorism, racketeering, etc. All of those crimes are specifically written in the federal code, in the United States Code, and they are federal crimes, not state crimes. It doesn't necessarily have to do with the seriousness of violence involved, because murder is a criminal case over here under the state law, typical first-degree murder. But these are cases that have been deemed to be within the jurisdiction of the federal government because of their involvement, usually across state lines, and usually with something that the federal government is in charge of enforcing. The other place you might see criminal cases in the federal system are through the appeals processes for federal crimes and habeas corpus appeals, criminal appeals that challenge the constitutionality of a criminal proceeding in federal court that have occurred in state court. So once someone has run through their appeals in state court, they can then challenge it under what is called habeas corpus, meaning in Latin, having the body, and it's a violation of someone's habeas corpus rights. So you'll see in a lot of criminal cases, once the appeals run out at the state level, they move to the federal level. But these aren't federal crimes, it's the appeals process that is going on here. So that means everything in this box is the type of things we typically think of when we think of legal action. So civil cases, any tort or wrongful action case, any contract case or other common law claim that is not a federal case, all of those fall under state court matters. Family matter claims, divorce, adoption, etc., birth, all of that fall under state court matters. And then criminal cases are really, by and large, state claims. Most crimes, up to and including first-degree murder, are state crimes, not federal crimes. Again, it does not have to do with the severity of violence involved or anything like that, but the nature of the crime and the way in which it is governed, and which kind of government is best for adjudicating it. So, what does that mean? That means that most of the cases that exist are not federal cases, but instead are state cases. And so we need to be cognizant of the fact that the cases that come to the federal courts, especially trial cases, and then appeals cases, we get state cases mixed in at the Supreme Court level, but we'll talk about that next week, are very narrow in nature. They are not the broad claims that we tend to hear about all the time. So, with all of that being said, what is it that our federal courts, how can we sum them up? How can we discuss them? The fact is that the Constitution is actually quite vague about the components of the judicial branch. Article 3 specifies that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. It does not set up a real rigorous structure for the federal court system. So one of Congress's first actions was the Judiciary Act of 1789, which set up our court system and the jurisdiction of the federal courts beyond what is specified in the Constitution. So some kind of key things to remember from this include the following. First is that federal courts have limited jurisdiction. As we talked about before, not all crimes are federal crimes, not all civil cases are federal cases. Federal courts now, under amendments and changes, have a three-tier system where you have district courts, which are the most common trial court, circuit courts, which are the most common intermediate appeals courts, and the Supreme Court, which is the final appeals court. It also has some original jurisdiction, but we'll talk about that next week. Congress defines the Supreme Court's appellate jurisdiction, meaning that Congress can limit what the Supreme Court can hear, the types of cases they can hear. Appellate jurisdiction means the ability to hear appeals from the courts below, now from the circuit courts that lead up to the Supreme Court. Original jurisdiction means that cases can be originated in that court. So there are some ways in which you can have a trial case heard in the Supreme Court, but it's very limited, and it usually involves lawsuits against a state or between states. And this is the structure of the federal judiciary. And I want to start from the bottom up. And this right here on the left side is the common path that we typically see cases take. We usually start in the trial courts. There are 94 district courts. There's at least one in every state, usually two. And then from there you can appeal. You have the right to appeal automatically. You can appeal to the U.S. Courts of Appeals, meaning you don't have to apply for an appeal, you just appeal. These are split up by geographic circuits, and we'll show you those in a minute. And then from there, you can appeal to the United States Supreme Court only if the United States Supreme Court allows you to present your appeal, and you have to actually petition the court to hear your case. We also have a lot of other trial courts that we typically don't hear a lot about unless you specialize in that area of law or policy. Those include the tax courts, the U.S. Claims Court, Court of International Trade. These involve really highly technical governmental matters, things like copyright, trademark, etc., and obviously trade cases. And then the military courts, which have their own system and then eventually dump into the Supreme Court. Bankruptcy courts are under the district courts themselves, so they are actually a subdivision of the district courts. This is that tri-level structure I was telling you about before, with the United States Supreme Court at the top, and then the trial courts, really the district courts being relevant here at the bottom. Michigan has two federal districts, the Eastern and Western District. So the entire Upper Peninsula is part of the Western District, and the Eastern District, which is the more highly populated district, is over here. There is a courthouse in Flint, but the main courthouse for the Eastern District is down in Detroit. It's a really beautiful building outside. And there is one courtroom that has not been completely renovated during the New Deal as part of the Works Administration, so it looks different than the rest, and it's quite an architectural gem if you're down there. The circuit court map. So remember, back in our linkage here, if you start in the district courts and you don't like the decision, you can appeal to the circuit courts, and that's divided up by geographical location. So all of the district courts in a state then dump into one of these numerical circuits rather. So Michigan is part of the 6th Circuit along with Ohio, Kentucky, and Tennessee. There are now 11 numbered circuits, and then there's also the DC Circuit, which hears certain things that come out of the DC district courts. There's also the Federal Circuit, which is somewhat separate from what we're talking about here. Congress can change these. In fact, they have. The 5th and 11th Circuit used to be just the 5th, and then they split off. So Congress can come in and change the way this is shaped at any given point in time, although there are reasons, obviously, you wouldn't want to do that because you're going to have to change where your courts are located and all of that. But this is done by geography, which means that having a court of appeals that maybe leans one way over another means that you might have slightly different interpretations of the law from one circuit to the next, different governing law from one circuit to the next. The idea is that the Supreme Court exists to kind of smooth that out and make sure that the law is applied uniformly. But before we talk about the Supreme Court, we have to talk about the case of Marbury versus Madison. And the reason why I want to talk about it here rather than next week when we talk about the Supreme Court is that it really sets up the idea of federal jurisdiction. It also sets up the idea of which court you should go to, and of course, the big one, judicial review. So Marbury versus Madison is a very interesting factual case, and I will put up a separate video about it rather than have me kind of just verbally tell you. I will let people give you a little more of a visual there. But the general issue in the case was whether Marbury could take his post as a justice of the peace for Washington, D.C. As you will note in the video, the idea was that the Adams administration was trying to put as many people in power before they left town, so that the Jefferson administration could maybe not do everything they wanted to do. The legal issue was whether the Supreme Court could invalidate a law of Congress. Well, how did we get here? What happened is Mr. Marbury, under a provision of the Judiciary Act of 1789, filed for what is called a writ of mandamus. A writ of mandamus would have provided Mr. Marbury with relief in the form of getting the job that he was promised by the government. So the Judiciary Act said you could apply for this writ of mandamus. He did. He took it directly to the Supreme Court. And the Supreme Court, who at that time, the head of the Supreme Court was John Marshall, who, by the way, was the person who put the seal on Marbury's appointment when he was Secretary of State, hears his plight and says, yes, we really do feel bad for you, Mr. Marbury. However, even though I personally am part of the reason why you didn't get your job, I am not going to help you out here. And the reason they didn't help him out is they said that this writ of mandamus that allowed Marbury to come directly to the Supreme Court was unconstitutional. Now bear with me for a moment on this because it gets a little complicated. So here's what happens. John Marshall gets the case, and John Marshall is not a fan of Thomas Jefferson either. Just like Adams, he's concerned that Jefferson is going to ruin the government, ruin the country, and history will kind of crumble, and the United States will be no more. All that doom and gloom exists. And so even though he would factually probably have liked Marbury to take his position and would have liked to give him that relief, he was a little more concerned about the stature of the court at the time and the ability of the judicial branch to act as a check on the other branches of government. At the time, the Supreme Court was kind of an afterthought. It was actually in the basement of the Capitol building. It was not seen as a co-equal third branch. So what he said really shook the foundations of what people believed the Supreme Court and the federal judiciary could do as a whole. Because ultimately what he said was that the Judiciary Act of 1789, that portion that deals with the writs of mandamus as a process that was available in the federal courts, specifically the Supreme Court, that part was unconstitutional. And this set up a couple of things. One is that it said it is now the job of the federal judiciary, specifically the Supreme Court, to say what is and is not constitutional. They are now the interpreters of the Constitution. And it also said that the judicial branch, in particular the Supreme Court, was going to be the interpreter of action in the other branches, whether the administration's action, presidential action, complied with the Constitution as well. Ultimately, the legal reasoning here that Marbury hinges on is the notion that if the Constitution did not, as one of the four ways that original jurisdiction can exist, did not include this writ of mandamus, Marbury cannot use this writ of mandamus, and Congress cannot allow this writ of mandamus because they would have to actually change the Constitution to change the Supreme Court's original jurisdiction. They said, you can change our appellate jurisdiction all you want, but the original jurisdiction is specified in the Constitution. And to change that, it's not a mere yay or nay vote. You actually need to go through the process of amending the Constitution, as we've talked about before. So, if I'm John Marshall, I have to say, I'm sorry, Mr. Marbury, we cannot help you. You need to go back to the district court. This is not the place for you. Ultimately, this quote that I have up here is what gets deemed as the creation of judicial review. So in the case, John Marshall says, "It is emphatically the province and duty of the judicial department to say what the law is." Meaning, we are the ones who get to interpret the law. We get to interpret what Congress has set forth, and we get to interpret whether the executive branch is living up to its end of the bargain as well. So it says that the work of the other branches is examinable by the court, and it sets the court up as a co-equal branch. Now, there's debate about judicial review. We often say, especially in introductory classes, that Marbury versus Madison stands for the notion that that it creates judicial review, but it actually kind of interprets what was already there. If you read the Federalist Papers, there was a notion that the courts would engage in judicial review. But it certainly stakes a claim for the court as the place where judicial review happens. So, this is where we'll go from here. Next week, we will take a closer look at the Supreme Court as an actor in this branch of government. It is an actor on par with Congress and the President. It is the highest court in the land, and whether legal scholars and lawyers like to think so or not, it is a policy-making institution. The following week, we will wrap up our talk about the judiciary with a discussion of judicial behavior and what that means from a political science standpoint and from a legal standpoint. All right, that's all for this week. See you soon.